Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. In one of our prior videos, we discussed the 3 most common types of visitor visas. In today's video, I'm going to discuss what happens if a foreign national enters the United States and decides that they want to extend their stay for a little bit longer. So in order to do this, you must understand that even though there's 3 different types of visitor visas, one of the visitor visas will not allow you to extend your stay beyond the limitation. So if you entered from a visa waiver country, meaning that you entered on ESTA, which stands for Electronic Systems for Travel Authorization, if you entered on ESTA, you will not be able to extend your stay in the US and you are limited to that 90-day period. However, if you entered on a B1 or B2 visa, you may be able to extend your stay by filing USCIS Form I-539 application to extend non-immigrant status. So if you're looking to file the Form I-539, let me give you 3 big warnings when filing this particular type of application. The first warning is that these applications take a very long time to process. So if you file an I-539 application and you ask for an additional 6 months stay, you should not expect the decision until maybe 7 or 12 months later. What this means is that if you are applying, you should note that you may not receive a decision before you have to leave. The second warning involves when you should leave the United States. If you are applying for an I-539 application, there is a question that asks how long you intend on staying. And if the government takes 7 or 12 months to make a decision, it doesn't give you the ability to remain in the US until a decision is reached. If you ask to stay in the US for a maximum of 6 months, you need to leave before that date, even if they haven't made a decision on your case yet. So the third and final warning, which is also our biggest warning, is to make sure that you file your I-539 application correctly. If you file it incorrectly with the wrong forms, the wrong dates, the wrong information, the wrong supporting documentation, most likely it's going to get denied. When it is denied, you're considered out of status, which means that you did not maintain your lawful immigration status on day 1 of the original expiration date on your I-94 arrival departure record. This means that the next time you try to enter the US with that same visitor visa, the Customs and Border Patrol agent is most likely going to tell you that you're ineligible to come into the US and that you have to reapply for a different visa. And once you go to that visa interview, and even if you explain your situation to the best of your ability, most likely the visa officer is not going to have any empathy, and they're going to tell you that you should have used a lawyer if you were not competent to filing an I-539 application by yourself. Again, these are our 3 warnings when you're filing an I-539 application to extend your non-immigrant status. Again, thank you for watching Winning Law. I'm attorney David Nguyen, and we hope that we have made immigration easier to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.